Hello friends, this is Sanjay. In this series, I will cover all the important concepts and topics from the law of torts as per the common LLB syllabus that is followed by all universities for 3-year and 5-year LLB programs. These are also the concepts and topics that are important for exams like the Judicial Services, UGC NET, LLM entrance and the All India Bar exam. In this part, I will give an introduction to the concept of torts and also cover the general principles of torts. First of all, let us understand what is the concept of a tort. Suppose a person commits a wrongful action or a wrongful inaction. That wrong can be a civil wrong covered under civil laws, or it can be a criminal wrong covered under criminal laws. If it is a civil wrong and it is not a breach of a contract or a breach of trust, then it is a tort. This concept of tort is neatly defined under Section 2M of the Limitation Act, which says that a tort is a civil wrong which is not exclusively breach of contract or breach of trust. To better understand the concept of torts, let us look at some examples of torts. Due to some negligence like playing with the music system and not paying attention to the road, a driver hits a pedestrian. It is a tort against the pedestrian who can seek compensation for the injuries caused. If a person commits defamation, which can be written defamation, libel, or spoken defamation, slander, against another person, it is a tort. If a person enters into another person's property without permission, it is a trespass, which is a tort. If a person commits assault or battery, both of them are torts and the victim can sue for damages. Now, you will remember that different categories of assault are covered under the Bharatiya Nyaya Sanhita as crimes. So, this is also a very good example of a wrongful action, that is both a civil wrong and a criminal wrong. So, the person who commits the assault can be punished under criminal laws and the victim can also sue for damages under tort law. Let us now look at the important definitions of the term tort. These definitions are important because you may frequently come across questions about these definitions. The word tort originates from Latin and Old French. In Latin, the word tortum meant something that was twisted or wrong. The Latin word tortum evolved into the Old French word tort, which also meant a wrong or an injury. The most important definition of tort is obviously the legal definition given in the Limitation Act. Salmon said that a tort is a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively the breach of a contract or the breach of a trust, or the breach of other merely equitable obligation. This definition is important because this tort is a civil wrong which is not exclusively breach of contract or breach of trust, is the basis of the legal definition of tort under the Limitation Act. This definition is also important because it clarifies that the remedy for a tort is unliquidated damages, and this aspect is usually asked about in various exam MCQs. Winfield said that tortious liability arises from the breach of duty primarily fixed by law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. This definition is important because it clarifies that every person may have a duty towards all other persons to act or not act in a specific manner, and that duty may be primarily fixed by law, and the breach of that duty leads to a tort being committed. For example, it is the legal duty of every driver to be attentive and to drive carefully. If a person breaches that duty and causes injury or damage to any other person, a tort is committed, and the injured person may claim unliquidated damages. In his book, The Law of Torts, Hugh Fraser defines a tort as an infringement of a person's right in rem. You may remember that there are two types of rights: rights in rem, that is rights against the world, and rights in personam, that is rights against a specific person. You have a right in rem against all persons, against all other road users, that you should be able to use a public road safely. This right imposes a legal duty on all other road users, all other drivers, that they should drive with due care. And if any driver drives negligently and causes injury to you or damages to your property, then your right in rem has been violated and you can sue for damages. This definition is important because you will see questions which are asking whether a tort is an infringement of a right in rem or a right in personam. When we summarize all of these definitions, it is clear that a tort is a civil wrong, which is not a breach of a contract or a breach of trust, and the tort is addressable by an action for unliquidated damages. In the next few slides, let us look at the differences between a tort and a crime, a breach of contract, and a breach of trust. I have given the information in the form of tables for better understanding. These tables are important because you may be asked to explain the differences in subjective questions, or this information may be used in objective questions. Let us look at the fundamental differences between a tort and a crime. A tort is a civil wrong covered under civil laws, and a crime is a criminal wrong covered under criminal laws. A tort is a civil wrong that causes harm or loss to an individual, directly affecting that individual. On the other hand, a crime is a violation of law that is considered as an offense against the state or against the society in general. The primary purpose of tort law is to provide relief or compensation to the injured party. In contrast, the purpose of criminal law is to maintain public order and safety, and to punish and to deter wrongful conduct. In a tort case, the parties involved are the plaintiff, which is the injured party, versus the defendant, who is the alleged wrongdoer. For a crime, it is the prosecution, representing the state or the government, against the defendant, who is the accused. In a tort, the burden of proof is the preponderance of evidence, meaning that it has to be proven that it is more likely than not that the wrong has occurred. But for a crime, it must be proven beyond reasonable doubt, which is a much higher standard. Negligence, defamation, trespass, and nuisance are examples of torts. Theft, assault, murder, and fraud are examples of crimes. Under tort law, the legal proceedings are initiated by the injured party, whereas in criminal law, the legal proceedings are initiated by the state or the government. In tort cases, the plaintiff and the defendant can hire lawyers to represent them, whereas in criminal cases, the prosecutor represents the state and the defendant has the right to a lawyer, which means that if the defendant cannot afford to hire a lawyer, the court will appoint a legal aid lawyer. Remedies for torts include damages, compensation, or injunctions. For crimes, the punishments can be imprisonment, fines, community service, or probation. And finally, a civil suit may be withdrawn at any time if the parties agree to a compromise. In a criminal case, since the offense is considered to be a crime against the society in general, there is no question of compromise, unless the crime is compoundable and such a provision is specifically provided for by the law. What is the difference between a tort and a breach of contract? A tort is when a person's legal right against everyone has been violated. For example, the right of a pedestrian to walk safely on a public footpath is a right against all other users of that road. Whereas in a breach of contract, the contractual right of one party are violated by the other parties to the contract. So the rights are against specific persons. Now, tort is a civil wrong based on some general duties imposed by law, which affects the right against the world, that is, rights in rem. Whereas breach of contract is a civil wrong based on specific duties outlined within a contract, affecting rights against specific persons, that is, rights in personam. Torts arise out of duties that are imposed by law and owed to individuals and the society as a whole, whereas breach of a contract arises from the agreements and the promises made within a contract. The purpose of a contract suit is to provide the relief and compensation to the injured party and also to deter wrongful conduct, whereas the purpose of a breach of contract suit is to enforce the terms of the contract and to compensate the injured party for the losses due to the breach. In a tort, any injured party affected by the wrongful conduct may sue, because tort arises out of a right in rem. For a breach of contract, only the parties involved in the contract have the right to sue. In a tort suit, the damages are generally unliquidated, that is, they are not predetermined and they are compensatory. And there is also a possibility of punitive damages in some cases. In a breach of contract suit, the damages are typically liquidated. That is, the damages are specified within the contract or by law. And the aim of these damages is to restore the injured party to the position they would be in if the contract had been fulfilled. Examples of torts are negligence, defamation, and trespass. Examples of breach of contract are a failure to deliver goods or services, non-payment after delivery, or violation of any of the other terms of the contract. In tort suits, the remedies may be damages or compensation, injunctions, and very rarely specific performance. In a breach of contract suit, the remedies may be damages, specific performance, rescission, that is cancellation of the contract, and restitution, that is restoration of the benefits wrongly received. And in a suit for tort, the defendant can claim contributory negligence, consent, or necessity as a defense. In a breach of contract suit, the contractual defenses like frustration due to unforeseen events, misrepresentation, undue influence, or mistake may be claimed as defense. A tort is defined as a civil wrong that causes a harm or a loss to an individual. On the other hand, a breach of trust is a violation of fiduciary duty by a trustee towards the beneficiary, thereby causing a loss or a harm to the trust property or to the beneficiary. The purpose of a tort suit is to provide relief or compensation to the injured party and also to deter wrongful conduct. A breach of trust suit aims to enforce the trust and to compensate the beneficiary for any loss or harm that is caused by the trustee's breach of duty. In tort cases, the parties involved are the plaintiff and the defendant. For a breach of trust cases, on one side it will be the beneficiary or a co-trustee, and on the other side it will be a trustee. Damages in tort cases are generally unliquidated and compensatory and may also include punitive damages. In breach of trust cases, the damages are typically compensatory. That is, they are aimed at restoring the trust property or compensating the beneficiary for the losses caused by the breach of trust. Examples of torts include negligence, defamation, trespass, and nuisance. Examples of breach of trust include misappropriation of funds, failure to act in the best interest of the beneficiary, and unauthorized investments. Tort proceedings are initiated by the injured party, known as the plaintiff. In breach of trust cases, the proceedings are initiated either by a beneficiary or a co-trustee. Remedies for torts include damages or compensation and injunctions. For a breach of trust, the remedies include restitution, removal of the trustee, compensation for losses, and specific performance of the trustee's duties. Defenses in tort cases include contributory negligence, consent, and necessity. In breach of trust cases, the defenses include good faith, actions within the terms of the trust, and informed consent of the beneficiary. Tort law in India is primarily uncodified. This does not mean that there are no tort laws in India. It only means that there is no one single comprehensive law covering all torts. Torts are primarily governed by common law principles and by precedents derived from English law and Indian court decisions. Different aspects of tortious liability are covered by various laws, such as the Bharatiya Nyaya Sanhita, which covers assault, defamation, negligence; the Consumer Protection Act, which covers torts related to consumer rights, defects in goods, and deficiencies in services; the Motor Vehicles Act, which covers tortious claims arising from motor vehicle accidents. Then there are the Public Liability Insurance Act, Environment Protection Act, Workmen's Compensation Act, Indian Contract Act, and the Specific Relief Act. From the Law of Tort syllabus perspective, we will be looking at the Consumer Protection Act and the Motor Vehicles Act later in this series. Let us now look at the essential elements or the constituents of torts. First of all, there should be a duty. The duty may be to act or to behave in a particular manner. That is a positive duty. Or it may be to not act or not to behave in a particular manner. That is a negative duty. For example, a driver has the duty to follow all traffic laws, which is a positive duty. And he also has a duty not to drive in a negligent manner, which is a negative duty. This duty is the legal obligation to avoid causing harm to others. And also remember that this duty exists because of someone's rights. That is, it is the right of every road user to be able to use the public road safely. So it is the duty of every driver or rider to drive carefully. Next, there should be a breach of that duty. In our example, the driver exceeds the speed limit on a road and jumps a red light. This action violates the duty of not driving negligently. Following the breach, there must be causation. Causation means that there must be a cause and effect relationship between the breach of duty and a damage or an injury suffered by the plaintiff. In our example, the driver's excess speed and the jumping of the red light caused the driver to crash into the plaintiff's car. The causation can be in fact, which is actual, or it can be proximate, where the cause and effect relationship may not be easily visible, but it is recognized as such by the law. And lastly, there must be an injury. In our example, the accident may lead to some physical injuries, some property damage, financial loss, or emotional distress. This element of injury confirms that some harm resulted from the breach of duty. A point to remember here is that the injury must be a legal injury and may or may not also be an actual injury. A legal injury means that a right of the plaintiff has been violated. We will discuss about this concept of legal injury in a different slide. When all of these elements are present, a duty to care, breach of that duty, causation, and an injury, all the essential elements required for a tort are present. Now we know that for a tort to take place, there has to be a duty. The duty may be to act or to behave in a particular manner, or not act or not behave in a particular manner. When a person does not follow the duty, there is a breach of duty. This breach of duty is called a wrongful act. And this wrongful act can be a malfeasance, a misfeasance, or a nonfeasance. Feasance means the doing or performing of an act. So malfeasance means intentionally performing an unlawful act. For example, it is everybody's duty to respect other people's property. Deliberately or intentionally acting in a way to damage somebody else's property is malfeasance. Misfeasance is where a person performs a lawful act, but performs it in a negligent or an improper manner, thereby causing some damage or injury. For example, a surgeon is duly authorized to perform surgeries. But if he does not follow proper procedures and causes injury to the patient due to negligence, it is misfeasance. And thirdly, there is nonfeasance, where it is the legal duty of a person to act in a particular way, but the person fails to act. For example, it may be the legal duty of a lifeguard employed at a swimming pool to save anyone who is drowning. But if the lifeguard intentionally does not perform that duty, then it is nonfeasance. Next, let us look at the mental elements in tortious liability. We know that in a tort, there is a wrongful act, which can be a malfeasance, a misfeasance, or a nonfeasance. In some cases, to successfully prove a tort, or as a defense against a claim of tort, the mental status of the person who is committing the breach of duty has to be taken into consideration. In some torts, like battery, assault, or trespass, the accuser may need to prove that the act was committed intentionally. For example, if I'm just following Google Maps and I drive into somebody's private road, it was not intentional, so it may not be a tort. If I know that it is somebody's private property and I still drove into that road, then it is intentional. Negligence is a situation where the wrongful act occurred unintentionally, but because the person failed to exercise due care. Many accidents occur because of negligence, because the driver may be distracted by something inside or outside the car and fails to pay attention to the road ahead. So due care was not exercised. Recklessness or rashness is where a person knows that acting in a particular way is risky, but still does that. Driving on the wrong side of a highway is a known risk. So intentionally driving on the wrong side is reckless or rash behavior. Malice is where a person commits a wrongful act due to ill will or an improper motive. Suppose two persons have previously had a fight and don't like each other, and one of the persons intentionally goes and damages the other person's property. because of that feeling of dislike or anger, then the wrongful act has been committed out of malice. Malice in fact is where an actual malice is apparent, such as the history between the two persons in our example. Malice in law is where the courts will look at the circumstances and presume that malice exists, even if it is not apparent. Then there is strict liability, such as in the Rylands versus Fletcher case, where the defendant may have taken reasonable precautions and not acted negligently, but is still liable for the damages. However, in strict liability, there are still some exceptions, such as an unpredictable earthquake or a storm, which are acts of God, or if the damage was caused due to the plaintiff's own fault. The strictest form of strict liability is absolute liability, which was laid down in the oleum gas leak case, where there are no exceptions whatsoever, even if all due care is taken and the damage was done due to an act of God, the defendant will still be liable. As we have previously discussed, one of the essential elements of a tort is an injury. Here we are talking about a legal injury, and a legal injury means that a private legal right of the plaintiff has been violated. There can be three scenarios. There can be a legal injury, and there is also some damage. It can be physical, financial, emotional, etc. Since both injury and damage are present, this easily qualifies as a tort. Or there can be Injuria Sine Damno, that is, injury without damage. That is, a legal injury has occurred because a right has been violated, but there are no other damages. Even this qualifies as a tort, because a legal injury is essential for tort, not any other damage. The third situation can be Damnum Sine Injuria, that is, damage without injury. There can be some damage, physical, financial, mental, etc. But if no rights have been violated, then there is no legal injury. This will not qualify as a tort, because the essential component of tort, that is, a legal injury, is missing. Let us look at two landmark cases to better understand the principle of Injuria Sine Damno. In Ashby versus White, the plaintiff, Ashby, wanted to vote in a particular election. He was legally entitled to vote, and he wanted to vote for a specific candidate. However, the defendant, who was an official managing the election, prevented Ashby from voting, citing some weak reason. So, Ashby approached the court, claiming damages, stating that his rights had been violated. Lord Chief Justice Holt, who presided over the case, established the principle of Injuria Sine Damno, meaning injury without damage in this case, which makes this a landmark judgment in tort law. He ruled that Ashby did not suffer any actual loss, like a financial loss, and even the candidate who Ashby wanted to vote for anyways won the election. So in reality, Ashby did not suffer any damage whatsoever. But Ashby's legal right, that is, the right to vote, had been violated, leading to a tort being committed, and Ashby was entitled to damages as a result. Another landmark case from India is Bhim Singh versus State of Jammu and Kashmir, where Bhim Singh, an MLA, was wrongfully detained by the police and was prevented from attending a legislative assembly session. The Supreme Court ruled that even though there was no actual loss suffered by Bhim Singh, his fundamental right of personal liberty was violated, resulting in a tort. So, the court awarded him compensation for the violation. Let us now look at two landmark cases to better understand the principle of Damnum Sine Injuria, that is, damage without injury. In the Gloucester Grammar School case, a schoolmaster set up a rival school next to an existing one, causing the original school to lose students and suffer some financial loss. Despite this, the court ruled that there was no violation of any legal rights, and the defendant was simply exercising his own legal right to set up a business. The court concluded that the plaintiff's financial losses did not result from any legal injury. So this case is a classic example of the legal principle Damnum Sine Injuria, that is, damage without any legal injury. In Ushaben versus Bhagyalaxmi Chitra Mandir, the defendant Bhagyalaxmi Chitra Mandir made a movie called Jai Santoshima. In that movie, some of the other Hindu goddesses like Saraswati, Lakshmi, Parvati were portrayed as being jealous and vengeful. This hurt the religious feelings of the plaintiff Ushaben, and she sued to stop the exhibition of this film. The court ruled that the plaintiff's hurt feelings did not amount to a legal injury. Although the plaintiff's religious sentiments were hurt, Damnum, this did not constitute a legal wrong, Sine Injuria. Therefore, the court dismissed the suit, emphasizing the importance of freedom of speech and expression. Talking about legal remedies in a tort, there is a Latin maxim, ubi jus ibi remedium. This is a simple concept which just means where there is a right, there is a remedy. In other words, if the law gives a right, and if that right is breached or violated, then the law itself will give a remedy. A simple example of this is in the Constitution, where Articles 12 to 35 guarantee a set of fundamental rights. If these rights are breached, then the Constitution itself offers some constitutional remedies under Articles 32 and 226. Similarly, in a tort, there are some rights that persons may have against all other persons, which are rights in rem. For example, all road users have the right to be able to use the road safely. This right gives rise to a duty, which is, it is a duty of all road users to follow all safety rules and drive carefully. If any road user drives negligently, it may lead to an accident. If another road user suffers an injury because of the breach of duty by another road user, it is a tort. This injury need not be an actual injury, but there must be a legal injury, where the rights of the plaintiff are violated. In such a case, the plaintiff can approach the courts of law and a remedy will be provided. So, this is the idea behind ubi jus ibi remedium. Where there is a right, there is a remedy. With that, I will conclude this part 1 of the series. If you have any questions or feedback, post a comment below. I will see you soon in the next part of this series. Take care and Jai Hind.